of the craft along with requested return of the passengers, and Asprantia returned them together at significant cost. Republica should compensate for all costs in the return. Republica may argue that Asprantia must pay for the part of the return that involved people because the rescue and return agreement is silent on compensation for returning people, but given the silence, courts should consider what state should bear the cost of return. Should costs be imposed on the returning state, an innocent bystander, or the requesting state, which most benefits from return? Furthermore, because the rescue and return agreement was prompted by sentiments of humanity, this court should consider what result will yield the best treatment of those in need of rescue. If costs are imposed upon the returning state, how likely is it that states will provide their most advanced technology and highest skilled personnel for the rescue? We submit that it is highly unlikely.
Counsel, it doesn't sound to me like if you come into the court arguing humanity and then you tell me that you know, if your country has to pay something that they'll be less humane. Is that really what you're arguing?
Well, in this instance, we received significant costs when we recovered and returned these individuals. And while our actions indicate that we took good care of these individuals, it would be dangerous precedent to establish that costs should be imposed on the returning state because other states may not follow what we have done. Second, Republica is liable for damage that Station Ferry's fuel caused to our rare natural habitat. Article 2 of the Liability Convention imposes absolute liability for damage by a space object to the surface of the Earth. Station Ferry was a space object, and
Isn't it the case that that was an emergency measure designed to save the lives of the people on board, that they had to dump their fuel?
Well, even if that's the case, because Article 2 of the Liability Convention imposes absolute liability, the reasonableness of that damage should not come into play. If we were dealing with Article 3 of the Liability Convention, that would be an appropriate argument.
So you envision no exceptions to this?
No, because, Your Excellency, this result is justified because people on Earth have not consented to the ultra-hazardous nature of space exploration and its negative externalities. So it makes sense that the state that...
But we have a whole bunch of treaties where we envision the operation of things in space. It sounds like consent to me. What do you mean by no consent?
Well, one of those treaties, for instance, is the Liability Convention, which imposes absolute liability. Because these treaties show what should happen as a result of space exploration, the reason why the Liability Convention imposes absolute liability is because of this ultra-hazardous nature. Furthermore, it makes sense that the state that benefits from space exploration would pay for the damage because it was not the one that was harmed here. Customary international law also imposes liability for environmental damage to another state. As my co-agent noted, one must use your territory so as not to harm another. And the trial smelter arbitration confirmed this maxim, and therefore liability applies to environmental damage to another state.
Do you know whether that was a private smelter or a government smelter?
I am also not aware of that. Third, we may prosecute those who caused the death of our nationals. The principle of state sovereignty is what permits a state to prosecute those who commit crimes against their territory. State sovereignty is one of the most fundamental principles of international law, so fundamental, in fact, that this court in Lotus stated, restrictions upon the independence of states cannot be presumed.
How did Dr. Vinay cause the death of your nationals?
Respectfully, Your Excellency, that is not an issue in this case because it is not the role of this court to determine the merits of domestic adjudication.
Well, I'm sorry, counsel. You told me that they caused the death of your nationals. I just asked you how.
Okay. I will go into why these individuals were liable for the manslaughter charge. Article 38 of the Statute of the International Court permits this court to consider general principles of law recognized by civilized nations. The U.S. Model Penal Code says that manslaughter is homicide committed recklessly, while the French Code Penal says that homicide is causing death by negligence. Releasing lipstick-sized metal objects into low Earth orbit is certainly reckless. As my co-agent noted, there were widespread protests of these incidents, and smaller pieces of debris than this have caused catastrophic damage in low Earth orbit. So a lipstick-sized piece of metal weighing 5 grams, orbiting for 15 years, would certainly pose a significant risk to others.
These are not the ones that the state authorized. It was the illicit act that is linked to the Starflight destruction. How do you draw a link of causation here?
Respectfully, Your Excellency, Dr. Vinay, as director of the Republican Space Agency, authorized release of these capsules into low Earth orbit, and the release was given here to Mr. Ash released these capsules at 350 kilometers, which also constitutes low Earth orbit. Both of these instances have the same policy rationales for why this is very dangerous.
But that was the unauthorized one. That was not the one that that was the one that caused the damage. The unauthorized one caused the damage. What they authorized was something else at a different orbit. So how is it you are imputing the illegal act of Mr. Ash to Dr. Vignay for a criminal charge?
Respectfully, Your Excellency, this was not a different orbit. While Captain Link might have duped Mr. Ash into believing that he was required to pay to release at this orbit, the authorized release was a low orbit. And while the compromise states that it was supposed to be released into low graveyard orbit, there is no such thing as low graveyard orbit. The only graveyard orbit is above the geosyncratic orbit. And if something were released into low Earth orbit, it would have to be deorbited in order to be safe.
Counsel, I think the facts indicated that there were protests or that there was some concern expressed about release of these remains into orbit, but that Republica had looked at that and had decided that it would be safe.
Respectfully, Your Excellency, in the compromise, there is no indication that Republica engaged in any sort of study. It merely came to a conclusion. We have no evidence as to whether they considered the protests and weighed whether this was a good idea or not.
Let me step back a second if she's answered your question. I'm a little slow coming after lunch here. Under the law, the state of your client, would you please define homicide?
The compromise does not indicate what the law of our state defines homicide as.
Would you think that there are disparate definitions that are applicable under certain circumstances?
There may be disparate definitions. However, it is not the role of this court to determine the merits of domestic adjudication. So regardless of what the definition is, this court should submit to jurisdiction.
So it's just jurisdiction we're talking about, and not the justification for asserting jurisdiction.
Yes, Your Excellency. And I will address two reasons why we have jurisdiction in this case. First, we have jurisdiction because we arrested these individuals while they were present in Esperantian territory. Article 38 of the Statute of the International Court permits this court to consider general principles of law, general practice accepted as law by states. Under the customary legal doctrine of male captus, when, as here, states do not have an extradition treaty, state sovereignty maintains a state's right to prosecute those who are present within their state, regardless of the circumstances by which those individuals are present. For example, in Alvarez Machain, the Supreme Court of the United States upheld jurisdiction even though the defendant's presence was procured by forcible abduction, a violation of international law, holding that once a defendant is present in a state, that state has jurisdiction regardless of other international obligations. Here, Esperantia did nothing like forcibly abduct these individuals, but because Republica did not have an extradition treaty with Esperantia, the Rescue and Return Agreement does not remove Esperantian jurisdiction. Furthermore, because Republica might argue that the Rescue and Return Agreement includes an unspoken implication that return is mandated no matter the circumstances, but the Rescue and Return Agreement does not specifically set forth any restrictions upon a right of a state to prosecute. As the Latin maxim goes, lex specialis derogat legi generali, specific laws overcome general laws. Therefore, absent a specific provision to the contrary, the Rescue and Return Agreement should not be allowed by presumption and implication to overcome one of the longest-standing principles of international law, that of state sovereignty.
Isn't the Rescue and Return Agreement very direct in terms of mandating return of the personnel? And it doesn't say except for, unless, state laws or criminal charges or anything. There's no exceptions. It's direct.
Respectfully, Your Excellency, under the legal maxim, under the Latin maxim that I mentioned, the agreement would be required to include a specific provision that would mandate return under other circumstances that are anticipated. Some circumstances that might be anticipated are prosecution, quarantine, medical reasons, but none of these things are listed. If the Rescue and Return Agreement were really absolute and unconditional under any circumstances and mandated immediate return, it would have said under any circumstance. It would have said immediate return. And it would have said, for example, that quarantine was not included in that, but it did not. Therefore, the Latin maxim should apply. Furthermore, the Restatement Third of Foreign Relations Law notes that a state may assert jurisdiction over non-nationals who commit crimes in their territory or that substantially affect their territory. Here, those who were injured in the Starflight incident were all Esperantians, so their deaths affected Esperantia. If there are no further questions, Your Excellency, we respect...
No, there is a further question.
Okay.
Let me back up a little more. I'm trying to really get a grasp of the need to assert jurisdiction over these two individuals at this point in time. Based on your own knowledge and the facts given, would you consider this an intentional tort or negligent homicide? It has to do with jurisdiction being one of criminal liability.
Well, here, Your Excellency, we would be charging for manslaughter, and so it isn't necessary to look into whether this was an intentional act or not.
Okay, so you're going to be ambivalent about the nature of this being, is it civil or criminal?
Yes, Your Excellency.
All right, and you don't know from the compromise that there's an extradition treaty that exists?
The compromise indicates that there is no extradition treaty.
Thank you.
Thank you, Your Excellencies.
May it please the Court, Mr. President, and Your Excellencies, my name is Albert Lai, and together with my co-agent, Mr. Andrew Knudsen, we represent the respondent state, the Kingdom of Republica. I will be discussing for 17 minutes the continued detention of Captain Link and Dr. Vianney and the damage to Starflight 1. My co-agent will be discussing for 10 minutes the costs incurred as a result of an emergency landing by Station Ferry. We reserve 3 minutes for rebuttal. Your Excellencies, this case is about private actors acting in private capacity who have exceeded any governmental authority that they were given. We accordingly ask that this court make 3 findings. First, Esperantia must return Captain Link and Dr. Vianney under Article 4 of the Rescue Agreement. Second, Republica is not liable for the damage to Starflight 1 under Articles 2 or 3 of the Liability Convention. Third, Republica is not liable for the costs incurred as the result of an emergency landing by Station Ferry. I will begin with the first argument that Esperantia must return Captain Link and Dr. Vianney under Article 4 of the Rescue Agreement. Article 4 requires these persons return, first because they made an emergency landing, second because they are the personnel of a spacecraft, and third because the duty to safely and promptly return is unconditional. The compromise states that Station Ferry did make an emergency landing after losing navigational capabilities. Both Dr. Vianney and Captain Link are the personnel of a spacecraft, as a UN COPUOS working group meeting in 2003 agreed that the personnel of a spacecraft refer to all persons on board a spaceship. And in addition, the humanitarian purpose of the rescue agreement supports an interpretation of personnel that would encompass all persons on board a spaceship, as the purpose of the rescue agreement is to ensure the safety of all persons engaged in space activities. Third, the duty to...
Has Republica reimbursed Esperantia yet for the return of those who they did send back to you?
Republica has not done so yet.
Why not?
Because we believe that Article 4 of the rescue agreement omits any language concerning compensation for the recovery and return of persons, in contrast to Article 5 of the rescue agreement referring to space objects, which does have specific language referring to compensation. And Judge Manfred Lax noted that the absence of language referring to compensation under Article 4 means that their compensation is not required for the return of persons.
If you were to pay them and they'd send them back, do you think that would help? Have you offered to do